We now have two guests who've joined us in the studio, and one of them is an advocate of the High Court, Willis Otieno. Good morning, Willis.
Good morning, Eric. How are you doing?
Very well. Good to see you back here.
Good to see you too.
Karibu sana.
Asante sana.
The other person is joining us for the very first time. Jedida Wanjage is a public finance management specialist, and she's here in the studio. Good morning, Jedida.
Good morning, Latte.
Karibu sana.
Asante.
That's a hot seat of the Situation Room. Willis is sitting on the friendlier one.
You're on fire.
Yours is the hot seat of the Situation Room. It's good to have you both here. We want to discuss what happened in court yesterday. 3 judges of the Court of Appeal in an application that had been taken to the Court of Appeal by the National Assembly as the first applicant and the Speaker of the National Assembly as the second applicant against versus various respondents. How many respondents in total? Okia Omtata and 55 others, who included the Law Society of Kenya, the Azimio la Umoja One Kenya Coalition, the Kenya Human Rights Commission, Katiba Institute, TISA, the Institute for Social Accountability, Transparency International Kenya, the International Commission of Jurists Kenya, Siasa Place, Tribeless Youth, Africa Center for Open Governance, Robert Gadho Kamwara, Trade Unions Congress of Kenya, the Kenya Medical Practitioners, Pharmacists and Dentists Union, Kenya National Union of Nurses, Kenya Union of Clinical Officers, Freddy Konyango Ogola, Nicholas Kombe, Whitney Gasheri Misheni, Cosmos Limited, Universal Corporations Limited, Regal Pharmaceuticals, Beta Healthcare, Dawa Limited, Medicel Kenya Limited, Medivet Products Limited, Lab and Allied Limited, Biofarm Limited, and many others. Yeah? All those. So all those were on the respondent side. And what came out of it was what is in the headlines today and what we shall be discussing. You'll tell us what happened in court, and Jedida, you'll tell us what that means. Okay? But to welcome you to the conversation, CT will give us the day's proverb. CT goes to one African country, Jedida, every week, and then he mines proverbs from that country, brings a proverb a day. And your job is to listen to the proverb and give us your interpretation of the proverb. Okay? He's told us that for the next couple of weeks, he will be in landlocked countries of Africa. Name one, Jedida. A landlocked country in Africa.
Well, we'll give you a hint. Since it's your first time here, Kenya is not a landlocked country.
Yeah.
That's a good hint, right?
It's a hint. Now you can continue.
Name any landlocked country that you know.
Landlocked countries in
Africa.
In Africa.
Like our neighbors.
Not very far away. Countries beginning with U.
Uganda.
Very good.
See?
Very well.
Yes, yeah.
Yeah. Now you're here.
Yeah.
Now you're with us. Okay. Siti.
Yes.
From where are this week's proverbs?
We are in the Republic of Burundi. You know how we in Kenya boast of 47 counties?
Yeah.
Them, they boast of 18 provinces. And one of the things that Burundi is known for, as well as Rwanda, is the hills that they have. Now, Burundi has 2,638 hills. So there are many, many, many hills. Okay? It is a population of around, 11.8 million. Not that many, but many. If you look at the size of the country, there are actually very, very many people. Now, the proverb. A visible stone does not harm the hoe.
A visible stone does not harm the hoe.
The whole
Jembe.
Jembe. Okay. A visible stone does not harm the hoe. So here we can talk about it in terms of one context is in terms of when you're looking at what is currently happening in Kenya. So if, for instance, the government listens to the public and what they are actually requesting for, then at the end of the day will not be where we are right now. Yeah.
It's a good one. Willis, what's your interpretation of this?
My intention of it is that once you're aware of your situation, then you will not make a move to disrupt that which can cause harm to you. So a hoe is used to dig. So when you're digging, you're always looking for soft soil. And when you see there's a stone somewhere, you'll avoid it. So it's about situational awareness, in my view.
Be aware,
Yes.
and you will preserve your hoe. That's a good one. That's a good. So, Willis, what happened in court yesterday?
In summary, what happened in court was that the Finance Act 2023, and I must say this, a Finance Act is a revenue-raising legislation that amends so many laws. Income Tax Act, VAT Act. It sets out how government intends to raise its revenue, and it increases, if need be, the charges or the tax imposed on those revenue legislation. So the court declared the 2023 Act illegal, unconstitutional, null and void. All that means is that all the amendments which were brought through that Act are no longer in place. And we are back to the 2022 amendments brought by the 2022 Finance Act. Now, Kenyans need to understand that this year's Finance Act bill was rejected.
Yes.
Last year's Finance Act has been declared unconstitutional. Now, William Ruto has been unable to come up with a finance legislation for the 2 years he has been in office. But you still have a budget, an appropriation. How are you going to fund your budget, if you don't have commensurate revenue legislations
Okay.
that is going to fund that budget?
Before you get there, how did we get to the Court of Appeal?
We go to the Court of Appeal from the High Court. The first cases were filed before the High Court. And the High Court declared certain sections to be unconstitutional, but preserved some.
Did all these 56 entities go to the High Court
All of
together?
them were parties. No, there were different cases.
So there were different cases.
And then they were subsequently consolidated
Okay.
and had. But in the High Court, it's actually interesting that you mentioned this. In the High Court, the court had looked at what is the budget making process. And they said the budget must have estimates of revenue and estimates of expenditure.
That's what a budget should have.
That's what a budget should have. And in the High Court, the court relied on Professor Ndungu's affidavit, where he had said, our appropriation bill has both the estimates of revenue and the estimates of expenditure, which was not the case. In fact, that is partly what saved them in the High Court.
The appropriation budget.
The Appropriation Act.
You were saying that the Appropriation Act contained these two.
It contains both expenditure and revenue estimates. But then it goes to the Court of Appeal, because Judge Majanja looked at it and says, okay, these are supposed to be done. And I confirm, Professor C.S. Ndungu has confirmed, the Appropriation Act has both revenue and expenditure estimates. Now, that to us was a shock, because when we look at the Act, it didn't have estimates of revenue. It only had estimates of expenditure. So that goes to the Court of Appeal.
Okay.
And the Court of Appeal now has an opportunity to look at that Act and says, look here, this only has estimates of expenditure. There are no revenue estimates. And so subsequently, you've seen the court declare, that is one of the grounds for declaration. The other grounds is public participation.
Okay.
But just to speak on this one of revenue expenditure and revenue estimates, that to me is the fundamental indictment of not just the executive, but also of Parliament. Because therein lies the mischief of what Kenyans have been going through. When my leader, Jimmy Wanjigi, coined the phrase budgeted corruption, because it is when you fail to include revenue estimates, you only include expenditure estimates, that is when you open up the tabs for people to go and take illegal loans and commit the people of Kenya onto, without initially disclosing to them what loans you are going to take. Because under the same laws, you only take a loan for development, for a particular project. So that should find its space in the budget, in the Appropriations Act.
Oh.
But if you leave it open-ended, you see Kenya government every day going to the domestic market to take loans. You are not told which loans, which projects are being funded by those loans. You are not told where Parliament approved for the taking of those loans. Now that ends up leading us to have a situation where we've now borrowed 60 years ahead. We've paid tax in advance through loans, 60 years ahead from today.
Okay. The other ground was public participation.
Yes.
So what is that ground?
You know, the grounds on public participation, the court says that because public participation, number one, is a basic principle of governance in this country, Article 10. And then Article 118 also compels Parliament to engage in public participation. And the court was saying, the moment you have public participation, the state owes a duty to take into account the views of the public. It is not meant to be a superficial process that you're just doing it to meet a target. You must take into account what the people said when you are making the decision. But in this particular instance, you find 90% of those who made representations to the committees of Parliament, their views were ignored. No explanation given why those views were ignored. So the Court of Appeal is saying, no, public participation, number one, is compulsory. It is not an inconvenience to the policymaker. It is a compulsory requirement. And you are compelled to take into account the views of the majority who appear before you.
Into account, not necessarily adopt.
By taking into account, it means that they must inform the decision-making process. So if you disagree with what the majority have told you, you must proffer reasons. Because it's within those reasons that anybody who wishes to challenge your decision subsequently can say, you're the one who is being unreasonable in terms of the reasons that you are giving for not taking into account the views of the majority. And Parliament needs to understand that they are merely trustees. They are not the owners of this country. The executive also are not the owners of this country. They are all exercising a public trust for and in the interest of the people of Kenya. That is why public participation is a core component of our legislative and policy-making processes.
Willis, when amendments are made in the third reading
Yes.
of the lawmaking process
Yes.
in the House,
Yes.
they're made by representatives of the House.
Yes.
All right?
Yes.
Do they, is what the Court of Appeal now saying that even that must then also be subjected to public participation?
In fact, that's a very good point, because I heard the majority leader Ichung'wah talk about as if they own this process. Parliament belongs to the people. So that you don't say that with the stage we've reached, we are going to make amendments that are now contrary to the views of the people. We are in the third reading, we cannot go back to the people. It behooves them to go back to their lawmaking process, their standing orders, to make sure that even proposed amendments that are going to take effect need to be shared with the public in advance. So that in the ideal, the proposed amendments to a bill in the third reading should be an amendment that is informed by the outcome of the public participation process. So you don't hide your kuficha white. You don't hide your amendments. You subject the bill to public participation. Then those contentious clauses, you introduce them in the third reading. They should be there before. So that any amendment, in the ideal, any amendment to a bill should only be informed by the views that have been collected from the people. Otherwise, you end up subjuging the public participation.
Willis, are we saying that, or are we to take the view that all members of Parliament, including the gentleman whose name you mentioned, are privy to this same information that you have, that they know, and that you have the authority that they actually know that this is the process they must follow?
I'll confirm that they are so much aware. This thing is done by design. It is designed this way. They are doing it to achieve a particular purpose. And that to me tells you the criminal mind.
So we're imputing mischief.
Yes. And actually, I call it a criminal mind. It's fraud that is designed, and all they do now is to execute it. So where they're being caught is at the execution phase of that fraudulent mind that they have. They're aware of it.
All right. So one of those petitioners who took the case to court in the first place is Senator Okiya Omtata. He's also joined us in this conversation, and we'll bring him in shortly. Senator, good morning.
Morning, Dugu.
Good to see you here.
Thank you.
Karibu sana.
Thank you. Good morning, Willis.
Good morning, Senator.
Sister, and morning, brother.
Yes, brother, I'm very well. Thank you. It's good to see you.
Senator Jedida is a public finance management expert.
Yeah, I know.
And she's here to, break it down for us. So this thing that you took to court and the decision that has come out of court, what is it going to mean to our budget and to public finance management going forward, right? So Jedida, just top level observation from this. What would reverting to the Finance Act of 2022-2023 mean today?
Reverting to the Finance Act of 2022 might be a bit difficult for the government, because first of all, we've had a number of issues. For instance, if you look at interest rate, if you look at the current precedents that are happening at the moment, going to the Finance Bill or Finance Act of 2022 will be a bit challenging. But basically, let me talk about it in terms of 4 key issues. One is the issue of the money bill. When you look at it in terms of the money bill talks about taxation. So, and when you're looking at taxation, there are 2 specific issues under the Finance Bill of 2023 that led to it being unconstitutional. And one of them is the issue of lack of what we call provisions extended in the Kenyan's Roads Board Act, and 2, the Unclaimed Financial Assets Act. So basically what the government can be able to do is ensure that these 2 are subjected to public participation. And when you're talking about public participation, let's talk about meaningful public participation. Because public participation is about not just listening to people, but giving them reasons as to why didn't you pick our proposals, for instance. Look at it in terms of the finance bill for 2022-2023. They didn't give reasons why there was they didn't pick, or they picked certain clauses of the finance bill. Then also looking at it in terms of, for instance, the housing levy. Even Okiya Omtata was present to it. Everyone was rejecting the housing levy. That's what we're talking about. Meaningful public participation. Listen to the people at the end of the day. So in terms of one, discriminatory, in terms of fairness, in terms of fairness and equity, the principles of public participation, or the principles of tax. We're talking about not overburdening the taxpayers. At the same time, when you're trying to get revenue, ensure that you do not overburden the taxpayers. So those are some of the challenges or key issues that have actually led to this finance bill being unconstitutional. Another one, he's talked about it, of course, it's about the legislative processes and also the concurrence between both the Senate and also the National Assembly. So basically, I'll break it into those 4. But fundamentally, it's just looking at those 2. That is the Kenya Roads Board Act and the Unclaimed Financial Assets Act. Yeah.
Does this mean the Court of Appeal and the judgment out of the Court of Appeal yesterday that said the Finance Act of 2023 is unconstitutional? After the rejection by the people of the Finance Bill of 2024, the government was reverting to just the amendments that had been contained in the Finance Act of 2023, like Willis Otieno has told us. But now that has been declared unconstitutional. So we go into the amendments to the tax laws that were in the 2022 Finance Act. Hey, how much money can the government raise then with a budget of 3.9 trillion shillings expected expenditure? What will happen to this?
Okiya Omtata, the good senator, had began, he had said, in his view. Senator, in your view.
Yeah, in my view, Ruto must go.
Eh.
Because what is the grounds for removal of a president? Inability to govern. One of the grounds. And Ruto is unable to govern. Resetting him to 2022, whose budget was that?
It was his and Uhuru's.
Yeah, that was Uhuru's budget. Uhuru was the president. Yeah, alikuwa spare wheel. Uhuru was the president. Now, his budget is now supposed to be spending. We are supposed to be in the. He should be executing his third budget. The one inherited from Uhuru is the one implemented, the 2021.
Yeah.
Because Uhuru virtually from June 30th, 2023 was basically a lame duck. We're just holding for somebody. So then who implemented that budget. The second one was the one that was 2023, the Finance Act that has been rejected by the courts. And the third one is the one that was rejected by the public. So if he cannot pass a budget, he's unable to govern. Because the only policy document you have in a government is a budget. So if your budgets are rejected twice, you lose legitimacy to govern. He cannot govern. And that's one of the grounds in the Constitution for removal of a president. So when you say Ruto must go, it's not an idle call. It's a call that this country needs somebody who can govern it. You've heard what our sister has said, Jeddah, that going back to 2022 is going to get a lot of complications. You see, why should a republic end up in complications? So the consequences of this decision are dire. And now the call to reset the republic has been given anchorage in law by the courts determining that the budget of 2023 was null and void. And they have used the word ab initio. From conception.
From conception, it was wrong.
It was wrong.
Senator, why are you leaving out Parliament?
Now,
Parliament has budget-making powers.
it has budget-making powers.
The budget is the one that has a problem.
Parliament has budget-making powers, but the budget-making powers in Parliament have been corrupted.
Yeah.
Both by design of the executive and whatever. One of the things is that this budget is supposed to come to the Senate. If you look at Article 249, Clause 3 of the Constitution, it expressly states that Parliament shall ensure that constitutional commissions and independent offices are adequately funded. The only budget-making process is under Article 220 and 221. There's no other special mechanism. So, when the Senate does not participate in it, Article 249 is violated. And that's then a failure of the system. So, for me, Parliament approved, that's the National Assembly, is that which approved that budget. And the National Assembly has entered into bed with the executive that they don't bring the budget to the Senate. They avoid the Senate like the plague.
So the 13th Parliament must go.
The House, the National Assembly. The National Assembly of the 13th Parliament has no business continuing to be in power. One, it was invaded and the people snatched back the delegated power when they invaded that house. Number two, it has got into bed with the executive and does not allow the budget to get to the Senate. So the Senate is denied the chance to input in the budget. Then it has come up.
What did the Senate do about it?
There's been litigation which is ongoing. There's litigation ongoing. So the Senate then cannot be lumped together with the National Assembly. So the National Assembly and the executive having gone to bed and made two budgets that have been rejected by the public and by still the public, even through the courts, and the public through the street, have rejected these budgets. Then this House and the executive have no business being in power.
Okay.
They should go, and we need to have new elections to institute that House and to institute an executive to govern this country. Otherwise, with all these achievements, will morph into nothing. And as a result, as regards the judgment, we have been having this question of auditing the budget. And this judgment has made something very, very critical clear for me, and I'm very grateful for it. It's something we've been urging, and I urged it very much in my petition. And by the way, my petition was only one that was allowed 100% the way it was. The others are allowed sections. Mine was allowed 100% the way it was. And among the issues was what is the limitation on the tax-making powers of the Republic? Can anybody just wake up and do taxation? The court said no. There must be a law made by Parliament. And ultimately, the taxes must be used for a public purpose. It doesn't end with the law. So when you talk of odious debt, which we have been saying, and when you go to the doctrine of odious debt, which was established when the Americans invaded Cuba in 17-something and we threw out the Spaniards, and the Spaniards had borrowed a lot of money in the name of Cuba, and they were saying, okay, America, you are the new masters, now you have to pay these debts. The Americans said, we cannot pay money that was not spent on Cuba. You borrowed money in the name of Cuba, but you spend it on Spain. Cuba cannot pay that money. So that's how we established the law, the international law of odious debt. The courts are reaffirming that here by saying that how the borrowed money, how the taxation is used is very important. So we come up with the doctrine of odious debt now. So when we audit our public debt, the audit does not end on what was borrowed. The audit must go to what was it spent on. And if the money benefited a regime or the owners of a regime, like we are saying the Eurobond did, then that is not a sovereign debt. That is a regime debt that cannot be paid by the sovereign. It must be paid by the regime. And so if it's obligatory that the sovereigns have to pay it, then the sovereign have to recover it from those people who are in the regime. So if Uhuru borrowed money that did not go to a public purpose, or Moi, or Kibaki, or Kenyatta one, then we have to go to their estates and recover that money if we pay that loan to whoever is claiming we borrowed the money. So this for me is a very, very foundational judgment. There's the issue of public participation and other issues that the Land Council has clearly explained. They're very fundamental. But there are also issues in the decision that require me proceeding to the Supreme Court. The issue that the money that has been taken from Kenyans using this law cannot be recovered because there's a presumption of innocence needs to be tested. Because a presumption of innocence cannot over a presumption of constitutionality. That's the word, isn't it, Wakili?
Yes.
A presumption of constitutionality cannot be relied upon to overcome a finding of unconstitutionality. The court has made a finding of unconstitutionality. And Article 2, Clause 4 of the Constitution says, anything in contravention of the Constitution, including any laws, is null and void from the beginning. So the court, for me to say that the money that was taken from Kenyans in terms of the levies on housing and whatever cannot be refunded is something we need to go to the Supreme Court to determine. The other issue for me that is very critical to go to the Supreme Court that the court did not address is the question of at what point is the concurrence by the speakers of the two houses, on I think it's Article 114, or at what point do they concur? And the court says that they agree with the High Court that there's no need for concurrence on the finance bill because the finance bill should not go to the Senate. And clearly you have seen that Article 249 talks about Parliament making the Senate. Article 93 defines Parliament as being the Senate and the National Assembly. So we need to go and test that. And what I've seen is that the National Assembly, the Senate being a small house of only 47 voters, we are 67, but only 47 vote. So when an issue comes, the House becomes more deliberative because everybody knows each other. So that peer pressure makes you be very focused on what is happening. Number two, the Senate does not expand, has not been corrupted with any funds. The National Assembly has been totally corrupted by CDF. So when the MPs go there, and I think in the last budget, I think the CDF per MP was rising to 200 million. So when this thing is thrown in, the executive says, scratch my back, we scratch your back. The MPs have misused this money, and the MP who tries to stand up, the Senate, the executive simply says, okay, we'll look at your CDF accounts, and you'll go to jail. So that is CDF thing has been used to steamroll the budget through the House, both by persuasion, that take this, I will give you this, take this, and through coercion, that you have not accounted for the last money. We are going to lock you up if you ukileta kierere. That's why you hear they are all in muted mode, and even those who are very, very eloquent and speak on the floor of House with the poetry of angels end up, when to get the budget, they begin stammering in broken prose.
So I'm hearing you saying, Senator, is that even out after this judgment of the Court of Appeal,
Yes.
you are going to the Supreme Court
We are going to the Supreme Court.
on some aspects of this judgment.
So far I've identified two critical ones. That's
Okay.
on the issue that the money will not be refunded, because the standard has been that avoid law confers no rights.
Okay.
And that is from the, I think, 18 something in the US. That standard has been upheld by our courts, that avoid law cannot be relied upon to benefit
anybody.
anything. It confers no rights, it's void, and it does not require a finding of the courts. That has been very clear in jurisprudence. So our courts are saying that the law was valid until the point they found it to be unconstitutional.
Okay.
Yeah.
I want to come back to Wakili, and then Jedida, you'll come in. Now, if we go back to the Finance Act of 2022, does it mean that this morning Mafuta should not attract a 16% VAT?
In fact,
Should attract 8% VAT?
at this point, any collection of VAT on fuel at 16% is illegal. Mafuta should be down by VAT 8%.
I think it's just not illegal. It's a contempt of court.
It's actually illegal. It's theft.
Yes, theft.
It's actually theft. Someone is robbing you.
Yeah.
It's actually theft, and the pump attendants and the petrol stations that have still maintained their pump price at 16% VAT are stealing from Kenyans and should be charged. That's the starting point.
But they need to be advised so
No,
by
not
the
advised.
regulator.
The point is, the court, a competent court of the jurisdiction, has told you what the law is. You don't wait the regulator to tell you, because the regulator is not a supervisor of the courts. He is not the one to interpret for you a court decision. The moment you've been made aware of an existing court order on a legal question, your duty is to comply. And it is not a defense of you to say, I am waiting for my regulator or a third party to advise me on how to comply with this court order.
Wakili,
Yes.
if, for instance, since following the trajectory of your argument, your employer has already been deducting money from your pay
Yes.
towards the housing levy.
Yes.
Now, it has been declared unconstitutional.
Yes.
For purpose of discussion, it has been deducted for the last 6 months. So you're saying it is the employer's duty to comply with the court order.
It is the employer's duty to comply with the court order. It is not the employer to say that I'm waiting for KRA or I'm waiting for the AG or I'm waiting for whoever to give me an advisory. Because remember, all these people you're waiting for were parties to the case. They were also litigants. They lost.
Okay. So if it comes into effect,
Yes.
so are we saying that the monies that I have paid I should be refunded?
In fact, what Senator is saying is correct. The monies that have been collected based on an illegal act, the collections were illegal. Those collections need to be refunded. In fact, the conversation today in the morning in the whole country should be how the Kenyan government is going to give back almost 300 billion Kenyan
Now you're in
shillings.
contempt of court. The court said that they are not.
No.
Until Senator
let-
Omtata gets a different
let me
opinion
explain.
from the Supreme
I
Court.
want to explain this. In
Willis,
fact,
I
want to explain this.
you
There are two
cannot-
limbs.
Okay.
What the court said was this.
Uh-huh.
The court said, on the prayer to refund the money, it was not pleaded in the petition. That was never a prayer in the petition. So we will not delve into it. That is the part A. And part B, they say, but in any event, there's the presumption of constitutionality. So the basis for a court is moved by pleadings. So you go to court and say, I want my money back. There was no plea on that in that court. So they said we are not going to delve into it. But the totality of what we must take home is this. The court has declared the legal instrument by which the money was collected to be unconstitutional. Ab initio, it's illegal. So what is the law on VAT? What is the law on housing levy? It is the law that existed as at 2022. So there is no legal framework for which somebody can deduct my pay slip for housing levy, independent of now the affordable housing levy. There is no basis for a pump attendant to deduct from my pump price 16% VAT. It is lost, and if they do so, it's theft. And we must claim the money back.
Okay, it gets trickier. That refund clause which you say was not pleaded in court, it gets trickier.
Yes.
All these months.
But it's not the court, the Supreme Court, the Court of Appeal got it wrong. It was pleaded. In my petition, it was pleaded right from the High Court.
It was pleaded.
A refund, it was pleaded.
So the judgment missed that out.
They missed it out.
And let me say this. In fact, in Okia's petition for the High Court, the judge also missed out the component of estimates of revenue and estimates of expenditure as components, because he said that is the law, but the government has done that already in the Appropriations Act. When it was opened, the Court of Appeal, it was not there.
This gets really interesting because what we are saying, I'm still on this track of refund. I get a receipt every time I fuel my vehicle.
Yes.
So what should I do? Work out how much I've spent.
And go to KRA.
Yes, and say, excuse me, guys, yes, 8% here. Please, give me.
In fact,
That's ideal.
In fact,
For the next year.
those who keep receipts like yourself, I'm actually looking for Kenyans who keep receipts.
Yes.
Because then you have a basis to go to KRA and ask them to give you a tax credit.
Okay.
And if they don't, we seek a declaratory order of KRA that going forward, my tax obligations will be less
because of credit.
this amount. Yes.
Jedida, come in. Some of then what amendments are contained in the Finance Act of 2023 included that VAT on fuel moving out from 8% to 16%. There was the pay, a new tax bands coming up, 32.5% for those earning between 500 and 800, and 35% for those earning 800 and above for pay as you earn. Digital assets tax on income from transfer or exchange of digital assets, and so on and so forth. So which of these amendments in the act are actually now going to have a direct impact on government? Because I now want to focus on the government is going to lose a revenue stream here.
Okay. So, based on the Court of Appeal judgment, from the discussions you're also hearing, it's going to have a big impact. For the, let me say the first one, the Income Tax Act, as much as per the Court of Appeal that they are not going to reimburse what was there previously, but going forward, it's going to be a relief, especially for the normal citizens who've been paying taxes. They pay, for instance, so the tax band. So you're going to go back to the previous tax band. So that's a relief to the normal employees. So yeah, it's a relief to them. But to the government, it's going to be difficult. They're going to have a lot of financial constraints because times have changed during that time vis-a-vis right now. There have been a lot of changes that have been happening. So the government is going to have to, for instance, reduce the loopholes in terms of taxes so that they can be able to collect, that's efficiency, to collect taxes with less loopholes so that they can be able to get exactly what they're supposed to have in terms of the budget at the moment. So maybe let me say immediately that is something that's going to affect both the government and also the private sector. Looking at, for instance, you're talking about investors, it's also going to have an impact in terms of investors because the lack of confidence in terms of the government, for instance, because things are changing rapidly, you know. At one time, you're not sure how much you're going to make in terms of income, in terms of the investments that you're making. So it's going to have a very big impact even for the government at the end of the day. So the government has to really, let me say, seal the loopholes. That's the point. They need to seal the loopholes
All the
so
revenue
that
loopholes.
they can be able to collect as much tax as possible. But at the same time, the Kenyans are going to have a sigh of relief because there've been a lot of financial constraints. So, yeah.
But this sigh of relief will also come with a cost, right? So sigh of relief in terms of how much is coming out of your pocket, but then also there's going to be an impact in terms of service from the government, right?
Yes.
So, for example, in 2022, 2023, the budget then was 3.2 trillion shillings.
Yeah.
In fact, when the president came in, he said, I want to cut this budget by 300 billion shillings. Okay. This year, the budget with the supplementary budget proposals is coming to 3.9 trillion shillings. There's an extra 700 billion shillings of a budget difference between now and then. So should the government review the entire budget and go back to a 3 trillion shilling budget?
Okay, that's a discussion that's a bit, let me say, a bit challenging in terms of what you've just said. Look at, for instance, education, right? The supplementary budget discussions have been going on, and they're doing cuts in terms of that. So there's going to be a lot of difficulties in terms of, for instance, providing just the normal basic services that we get from the government. So it's going to be challenging because, again, another budget cut, can imagine. So it's going to be challenging. If you look at, for instance, they've already done a lot of budget cuts for very big top MDA levels. So you can imagine now continuing to reduce these. It's going to have an impact. The TSCs, it's already going to affect them, right? With the current supplementary budget discussions are still ongoing.
Okay, let me ask the question a different way. Jadida, as a PFM expert, was there justification to increase the budget from last year, January? The budget for the country was 3.2 trillion shillings. This year, July, the budget is 3.9 trillion shillings. Was it justified to have such a huge rise in proposed government expenditure?
Try yes or no.
Okay,
Or
it
let's
depends. Let me say it
30th,
depends.
30th June last year, 2023, the government is spending 3.2 trillion shillings. 1st of July, 2024, the government wants to spend 3.9 trillion shillings. Is it justified?
But I think to help Jadida, in the face of the judgment that this court has made, declaring the whole thing nullity, there can be no justification. It's null and void ab initio.
No, does it make sense
Maybe
to propose to
land
spend?
council can expound more on that, the impact of the
Look at it this way. You cannot raise within 1 year, you're trying to raise an extra 700 billion. I mean, it's the same economy. Nothing has happened exponentially in the last 1 year that your economy is growing by 700 billion. You're able to release 700 billion, collect 700 billion in 1 year. Look at how long it took, for example, Kibaki to take our budget from
300 billion.
300 billion to almost 900 billion. It took him 10 years.
10 years, yeah.
It took Uhuru 10 years to get it from 900 billion to almost 1.2
trillion.
2 trillion. So, and yet Ruto wants to do it in 1 year. I mean, that makes sense. And just to also address this point, you know where we are now? We should be going back to changing, then collapse the entire budget and start the budget making process afresh. Because if we don't do it, what these guys are going to do is this. They are going to open up and continue this illegality by going to borrow illegally from banks to cover this hole. And this is what has led us to this mess that we are in today. You saw Moody's downgraded us, and downgraded 3 banks in Kenya: KCB, Equity, Cooperatives, to C, CAA. Now, that is almost the junk bond thread. And these are the ones who lead in lending to government from the domestic market. This is a danger, and Kenyans need to wake up and say, no.
We've got to end it there. Thank you very much for joining us this morning. These conversations, of course, have just started. We'll have to continue them in coming days. Willie Sutieno, Advocate of the High Court, Jedida Wanjage, PFM Specialist, and Senator Okiya Omtatah.
This is the Situation Room, the only way to start your day.